Welcome to Dental All Stars. I'm Alex Nottingham, founder and CEO of All Star Dental Academy. And with me is David Ehrlich, managing partner of Ehrlich Law LLC. I also have Eric Vickery, our president of coaching, with me. And we're talking about this issue of how the FTC banned non competes and how this may or can affect dental practices. So, welcome, everybody.
Hi, Alex.
Hello.
Hi, Eric.
Yeah,
Hey.
so Eric sent me this email, and he's like, this long email, FTC bans non-competes. It's like, how does this affect us? And I'm like, Eric, it doesn't affect you, FYI. And we'll get, as a side hustle, we'll talk with the attorney. And Dave is an attorney, if it wasn't obvious, right? Law firm. And I'm like, well, you have to get my buddy Dave. He does this stuff, business law and contracts and so on with his firm. And so we wanted to talk to a practicing lawyer. I'm a lawyer that I did pass the bar. I'm a lawyer, but you wouldn't want to hire me. I'm not studied like David. I don't do it for a living, get you in trouble. So you talk to a real attorney here that does it. So thank you for being here. So I guess, Eric, let's start with you. Lay out the issue. How did this come about to your attention? Or what do you
It,
not know or what?
it, I'm going to be the client in this scenario, and I'm going to be the one pretending like I'm the client, going, "What just happened?"
You don't even
I
know what's
have,
going on. Yeah.
I'm an owning doctor. I've got an associate, and all of a sudden, this email passes my desk and says, "Guess what? That non compete you have with your associate does not matter," and I'm freaking out now, and I don't know what to do because that's how I got the email sent to me.
Okay.
So here we are.
Well, Eric, and Alex, I'm going to do a couple things. First, I'm going to do the classic lawyer. This is over a podcast. This is not giving legal advice. I'm only my license is limited to Florida. So if you are not in
Oh,
Florida,
boo.
this is not providing legal advice to anywhere
Right.
outside of Florida. And even if you are in Florida, you are not my client. This is a macro bird's eye view of some issues that will be coming down the pike. But what I will say is, let's put yourself in the shoes of what Eric just the hypothetical that Eric just said. You're a doctor, you have an associate that has non-compete agreement in your office, and you say, "Oh my goodness, I just read this email. I just read that the FTC came out with this ruling. What do I do?" Okay, a few things to keep in mind. One, the FTC is not Congress, and Congress is not your state legislature. So, in fear of, and I am not also not a uh, be all end all person to make these decisions. I can assure you that for the next 3 to 5 years, we are going to be reading about whether this decision will have any legal effect. Because what this is a policy statement of the United States government. Okay, is what this is. Okay, now the FTC is headed up right now by a very, very interesting and incredibly motivated, and who I find fascinating woman, who could be one of the most important women of our people of our time, and it's Lena Khan. I highly, regardless of what your interests are in life, read up on a woman named Lena Khan, Khan. She's the head of the FTC. The Wall Street Journal had a great write up on her in March, because her primary motivation in life is antitrust. Okay, and this is breaking up big monopolies and promoting competition. Okay, that is where this comes about. Now, because she has attacked that from the macro side, big corporations, this is their attempt to attack this from the micro side, from the down all the way from attacking Amazon and Apple down to the local dentist practice, right? And this is now we're now seeing that possibility, right? And now this is policy. My opinion is that this is a policy statement that has no direct legislative effect. Now, the important thing to keep in mind is, and this is where it is possible to have some actual teeth to it, is that the FTC has come out and called non-compete agreements uh, that they are actually an unfair trade practice. Okay, and that they argue gives them the right to take some kind of enforcement action against it. All right, and that they call them void. All right. Now, that still, in and of itself, does not automatically create that, does not render it void automatically. There is going to be a bevy of litigation. There's already 3 lawsuits challenging the validity of this. The day it came out, uh, numerous lawsuits were filed. The United States Chamber of Commerce has come out challenging the constitutionality on several grounds. And just some inside baseball stuff, when we all first started talking about doing this together, the first thing I said was, well, that's a executive agency. It's not Congress, right? And that is the primary basis that they're challenging this. This is not Congress. So without getting too far afield, let's get back to the doctor. What do? There's a couple different things you can do. All right. First, you can do nothing. This doesn't go into effect until September. These lawsuits are seeking immediate relief from the court as to whether this is going to go into immediate effect. And we're likely to get some kind of federal court ruling before September that will either enjoin, which means that it'll stop from this rule from going into effect, which means non-competes with workers are void and not enforceable. Uh, you can, you know, be proactive and say, well, look, if the United States government is calling these void, I can get ahead of this and take this opportunity. Call your local, contract attorney that you've been dealing with all these years, have she or he help you work through it and perhaps redo some of your independent contractor agreements or uh, your employment agreements with your staff, depending what you have, which I highly recommend everyone to do. And omit various provisions of those agreements specific to the non-compete agreement, and omit those if you want to get ahead of it. Uh, there are some middle ground things you can do, like non-solicitation agreements, that you say, okay, well, look, the primary reason I don't want you to go into business for yourself is that I don't want you to go after my client base. Some of these rules in this long opinion that the FTC came out with leaves some room for middle ground on
Right.
that. And maybe we should get more into that, but
Yeah,
it's
yeah,
a
yeah, yeah. Mhm.
500 page
Wow.
leviathan of a
Good word.
finding.
Look that one up.
And so, that's your, what
I
do
don't
they
know what
call
that
it, five
means. I
That's
don't
a
five
know.
word
dollar
of the
It
word.
sounds
day.
big though.
Uh,
Man, must be a
so
lawyer.
so kind of like breaking it down. So from a policy perspective, the federal government is saying, and I guess it makes sense to some extent, right? That you don't want to inhibit people to have a livelihood unnecessarily. They did make the exception for executives, senior executives. That could be a dentist as an executive, a DSO, or a big dental business that has a to stop them from then doing what you're doing in that area. It did exempt, I believe, like if it's a buy sell agreement, that makes sense. Like it has to have some justification, but it's saying if you have associates and you put them into these non-competes, now they can't make a livelihood. You're restricting that. And so that makes sense from a policy perspective. So like David's saying, you can get ahead of it and understand David's a brilliant political mind. So he's explaining how that this is laws are based on policy and trying to do something of how you want the government to work and how you want trade to work. So of course, most people don't want to restrict trade and restrict people making a livelihood. However, so that's with respect to the associates. So you can get ahead of it. Now you were talking about non-competes, non-solicitation, intellectual property that your clients are intellectual property and you can restrict them. Let me ask you is can you because you can kind of get to the same end, right? Nobody's saying when you associate leaves, you can't make a living. You're saying don't affect me what you already did. Don't take my clients or the current patients, and don't solicit them. So let me ask you, David, because it gets to the same point. I would think, Eric, let me ask you, and then I go, David, with the dentist that Eric being our president of coaching, working with a lot of clients and many coaches under you, um, and we help dentists onboard associates because associates are important to make money. Is that the biggest concern from a policy perspective that we want to, when associate leaves, we don't want them taking our patients, correct? That's the main
Yeah,
concern, right?
exactly. Yes.
And that's what the non-competes are there for. So, David, this is what we can do with law, right? Find the book. How do we still achieve this end if non-competes are not in order?
Well, there's a few different things to keep in mind. One, uh, some of this is still going to be based on geography. Okay, this is a state issue, and that's another part of whether this all matters, because this is the first time the federal government is attacking this. So I still can't stress this enough. This matters what state you're in. If you're in California, it's going to matter a lot. It's going to be different for folks who live in California from people who live in Florida, for example, because in California, non competes are already generally prohibited, and in Florida, they're generally permissive. And so, for example, in Florida, what I'm accustomed to is Florida is more of a errs on the side of promotion of contract and the ability for business to operate, whereas other states are more consumer protection in line or worker friendly, right? Or worker defer to the side of employee versus employer, right? Is the best way I would say that. Uh, and here, but to get back to the specific question, what can I do? Non-solicitation agreements, so long as they're tailored to this potential new rubric, that do not limit the ability for the person to operate this specific type of business or work for a different employer, that so long as that does not include contacting potential patients, then I'm interested in is how that develops and how those things overlap. Because in my world, those two things go hand in hand. And if now the FTC is saying you can have one without the other, I am interested, because I don't I am interested in that interplay, because I'd love to give you a one word answer. Sure, just cut out the non-compete part, keep the non-solicitation part, and then we all live happily ever after. I'm not going to give you that answer because I don't think it's that simple.
Yeah.
I see a world where, and I'll give you the doctor associate example. I think is the most complicated here, because if you and I have if I'm your associate and I leave the practice because for whatever reason, and now our non-compete is no longer enforceable, and I go to a different practice, and the only thing that survives is my non-solicitation agreement, and those under this surviving agreement, I can't contact uh, the existing patient role that you would have had, right? That I would have been not permitted to contact while working at your practice. But if those patients follow me because they saw something that led them to me, right?
Mhm.
That
Organically.
is still going to be a source of contention between us, and that is still going to be, who contacted who, how did you learn of my existence at the other practice, and it's still going to be the source of discontent, so to speak. And I'm curious on the interplay of how that is going to work, because as much as the FTC um, have spent quite a bit of time trying to limit those. They're trying to be narrow and still promoting business and still allowing business to thrive, but they want worker movement without the restriction of worker movement. I am curious in this, how broad that's going to go, and we also know that lawyers can be very creative in finding areas to say that this creates a private right of action, and that it's a violation of my freedom to go work somewhere else, that I wasn't able to contact somebody or
So
whatever it is.
if this goes into play, let's say it's upheld or the Congress supports it, whatever, that's the baseline, meaning Florida cannot lower lower the protection. They can only add more like California. You can never go below the federal government. So you're saying this is an executive action. It's got to be upheld. And if it is upheld for whatever reason, then no state law can lower it, correct?
That is if all of
In
this,
theory,
in
if it goes through.
theory,
Right.
in theory.
Once it's affirmed, if it's affirmed as legal, then you can't do that. Now, and like you're saying, there's lawsuits and things that will go on. So it may just be postponed or whatever. Now, could you, and you're saying getting ahead of it, could you just say, all right, for the meantime, make sure all your agreements have the non-compete, non-solicitation, IP protection, NDA, all that good stuff, um, all in one. That, I mean, what's the harm of that?
I would certainly encourage folks to keep whatever you have. I would also encourage folks to um, be mindful of the possibility of this being a bellwether for where policy goes forward. Um, it could have the opposite effect, though, that if this is found to be unconstitutional, that states that are pro business could have a rubber band effect, as they say, that could actually expand employers' rights as to what can be uh, uh, what employers can contract for, and then conversely, in the other states that are more employee friendly, what can be additionally restricted. So, I guess my statement
Because
to
it could, you're
you,
saying it could strike down the other way, that if there's a Supreme Court action or something that goes on, that it could say, "Hey, California, you cannot, not only is this unconstitutional, not permitted," or if the legislature puts something that, restricts it, it could say, "You can't add these additional protections that go too far." So you're saying it could go the other way. Now, is there any harm of having the provisions? Um, I mean, basically, it would only, so let's just go, a scenario happens. Let's say I'm in Florida here. I have all of them. Let's just say it was upheld. Well, it's upheld. Once it's fully upheld and clearly illegal to do it, you're going to have to change it. Well, so there's two scenarios. One is it's unclear and I have everything in there. It is clear and I may continue to have it. Really, lawsuits are only an issue when they happen. So you can talk all you want now, because ultimately you just, I mean, as long as you don't get dismissed, you can bring the lawsuit. Associate violates your agreement, you go and you file a lawsuit against them, and they're going to file motion to dismiss whatever. So from a strategically, like, uh, if I kept that provision in there, would it hurt me? Or would the judge just say, okay, I'm not going to, section A, I'm not going to allow, but B and C we can look at. There's an issue of fact there or whatever.
there's two issues to that could come to pass. One, regulatory compliance enforcement can be a thing,
Hmm.
where, for example, I'll just give you a total example where um, the CFOs and the Department of Revenue of states often will ask medical practices for copies of their employment agreements or their independent contractor agreements to ensure that workers' compensation laws have been followed. I can see a
Oh,
world
good point.
I can see a world where this is something that is something they check for, right? Because states are always looking for, and this is me thinking outside the box, Alex, to be honest with you. But if they they hire me for looking for revenue sources, this is something I would suggest. Uh, I hope they're not listening. They would, I would say this could be something they would look at, right? The same time they would do those kinds of Department of Revenue audits, and the for whether they're properly disclosing employment when they're using independent contractor agreements instead of
And I had one of
employees or
those.
W.
Yeah.
Sure,
And we were
uh,
okay, but they wanted all the
good.
agreements. They want to see what's going on. So you're saying if you get audited, they could say you're in non-compliance, you're doing something improper, you got to fix it, and we're fining you, potentially reprimanding you for doing that. So okay, so you can get ahead of it. But the point is that, so what I'm hearing right now, just like, uh, you know, make sure you have an attorney ready, to be ahead of it, that if this is upheld, that you cannot use that provision, but have other provisions. Lawyers are designed to be creative to still get that upheld. And I'm sure, again, from a policy perspective, I don't know what the FTC is thinking. Maybe they're not thinking dentists, but we also don't want to we don't want to burden uh, dentists or business owners from people taking their stuff. And I would argue that patients are your IP. There's also, this is an equitable, I think, law, not necessarily some statutory here, but procuring cause that I procured these leads. I put money in and marketing to have them come, and you're unfairly benefiting, unjust enrichment. There's a lot of things that you could argue, either statutory or equitable, to be able to. And the point is this: look, part of, and David, you can attest to this, because often lawyers will say, is it worth it to bring the lawsuit? You can be all right, but is it worth it? And from, look, my dad, as a dentist, his associates took people and left, and he didn't want to sue him because he's a super nice guy and love him, but potentially had a claim, but he didn't want to go through the law, the stress, and all that. And you have to say, is it worth it? They took one or two patients. Is it worth it? They took 20 patients. Now I sue, and just having a lawsuit is the, if you are going to do it, is a stressor for both parties that they got the message. It's like, listen, I'm watching you. Even if you lose a lawsuit, as long as you're not frivolous, you're saying, listen, I'm going to enforce my rights. This is how we do it. And it was stressful for everybody. That is because, again, we get into law. Then it's where you guys, David, say, is it worth it? Is this what want to do? And being vindictive usually doesn't work. But if you are upholding the right to work and your business, it's there. So you have to look at multiple scenarios. This is where your great mind is. You're talking about, this is amazing. You talked about the political perspective, the regulatory perspective, the business perspective, the is it doesn't make it sense to enforce perspective. So all these things you have to consider.
Yeah. Uh, a few things, Alex. Now, I think, and I liked where you were going with trade secret because my understanding is they sort of skirted that. You use intellectual property in terms of what uh, your patient list, your confidential information, and the non something that might be covered under an NDA or non-disclosure agreement. Uh, a few things to that effect, and that is that you can still use what is in the right to contract to do your best to protect yourself in this environment from those things by using those types of agreements. And my understanding is that the concept of trade secret is relatively unaffected by this. And trade secret is so inviolate that there's, at least in Florida, there's definitely statutes that go to this specifically, and even in Florida's non-compete statute. And again, I encourage you to consult your local jurisdiction and your lawyer in your jurisdiction's ability to consult the your state's non-compete issue one way or the other. But in Florida, there's actually a separate component to the non-compete statute of whether how many years is presumed reasonable and unreasonable if it's related to a former employee, if it's related to the sale of a business. Say you buy someone's medical practice, you buy a dental practice versus trade specific to trade secret. And so you just straight up buy someone's client list to the extent that's
Oh,
possible,
okay, that's interesting.
right?
So let me ask you this. So we talked about the associate
Patient list.
situation. What about you're selling the business? What about you're buying the list? You're buying the patient base, and maybe not the physical, which happens. You buy the patients and not the facility. Eric is saying yes. In those two scenarios, and by the way, we have I'm being chatted here. We're live streaming. I got over here. We got a dentist who is on our YouTube channel, and we're chatting away. So we'll see if questions come up. And we're also on Facebook and LinkedIn Live. So if you have questions, just chat them away. Um, so yeah, about those scenarios, you're selling a business or you're buying the book of business. Um, does this FTC situation apply in non-competes?
No. So they call it the final rule because the FTC has been investigating this for a long time. So you might hear me say the word the final rule, but the ultimate decision, this 500-page, I call it Leviathan earlier, does not apply to non-competes entered into by a person pursuant to a bona fide sale of a business entity. So the straight up answer to the sale of a business component is that that is somewhat immune to this. Now, the other components are, it is still ultimately going to apply to the worker bee level. Okay. So hygienists, front desk associates, those are the two kind of primary bread and butter components to this. Those, and stop me if I'm wrong, but my thoughts would be, you have associate dentists, you have hygienists, and you have staff. The staff and hygienists and front desk folks, that is who this is primarily going to. Okay. This rule is primarily trying to tell you that as of September 4th, the United States government wants to tell you that non competes are going to be void as to those folks. Okay. A lot of lawyers in your local jurisdiction, I would defer to them. I am telling you that I am not convinced that it is automatically enforceable. And I think we will get some ruling from a federal court that will say it is automatically enforceable right now, or it's not. Okay, because of these pending federal actions seeking to enjoin it. Uh, Now,
So
there
real
was another
quick,
question in there
yeah,
also.
I want to clarify something. First of all, I want to say to all the dentists and dental team members listening, this is how your patients feel. Ha! This is why we teach verbal skills. Listening to these two guys talk is like listening to mumbo jumbo squeezing my brain. So I want to see if I'm understanding. I'm going to simplify this, make this really, really simple. It's a little too early to worry. We don't really know too much. We'll know more in September, but it's a good idea to meet with someone in your jurisdiction to say, hey, do I have an NDA and a non solicitation agreement in my contract? Is that good? Did I catch
Yes.
what
Uh,
I need to catch? Okay.
yes,
All right.
yes.
And
Eric,
confidentiality. Oh, you maybe
yes.
mentioned that. Yeah.
I do.
Confidentiality.
I will take it one quick step further, Eric. And I think there's three kind of buckets that I would put dentists and practice owners in, of where they might fall. And some of this might depend on your jurisdiction. Okay. There's the do nothing and wait and see, because you have until September. We think
Mm,
there's going to be some rule one way or the other.
mm.
And I apologize for the YouTube folks, because the sunlight, I have an office window and it's set up right on my face. So I don't know if can
You look
rearrange
great.
myself.
You look great.
Thank you. I wish I looked like YouTube, but we'll see. Now, next, there's the folks that might be persuaded to embrace the future. You're okay with this and you want to get ahead of it. And it's okay with you that you just say to yourself, okay, I'm not getting anything out of this non compete issue. It's more hassle to me than I've ever gotten a benefit from. I've never sued anyone over this. I've never even followed up with anyone that's ever left me to even care about this. The only thing I really care about is the confidential nature of my client list. So as long as they're cool signing that, so be it. Consult your local, attorney. Make sure that's still kosher, and go with that. And then there's something of a middle ground, which is, and we touched on this, but we didn't get too specific, and that is retain non-competes for your higher level executive. They call it higher level executives in the opinion, and that's why I'm using that language.
That's what
You'd
Eric is at All Star.
there you go. See. So you'd say, that these are your associate dentists. These are perhaps your junior partners at a PA. These are, junior members of an LLC practice.
So you're saying
You know,
associate dentists may rise to the level of a senior executive.
I'm glad you asked that, Alex, because
Yeah.
that is at
Good.
least defined by this opinion as those with over $151,164 in annual compensation and in a policy making position for the business. That
Okay.
is
So let's
the
break that into two
back of
parts. Let's
the
break this
that
two
is the
parts.
back of the envelope
Okay.
definition.
We
That
Well,
is
finally
that is the
got there.
synthesis.
there's 2
That's a
Okay.
points.
synthesis.
I think the second point might get these associate dentists out,
Yes.
right, Eric?
So let's break it down. So anyone earning as a W-2 employee, does that matter? Anyone
Uh,
earning 151,500
That's a
or
great
more?
question.
So it says annual compensation. Now that's something of a nebulous term,
Doesn't
because
say
Okay.
that could
W-2,
be
yeah.
a owner distribution.
Okay.
that could, you know what I mean? Because a lot of
All right.
medical practices and a lot of dental practice have moved to the 10K
Yeah, a
model.
lot of them are doing well, and a
Yeah.
lot of
Wow, this is huge.
associates
This
are
is the
doing
most
1099.
important part right here, Alex. This is
Okay,
because
for the associate
almost
side,
every yeah, because almost every associate is going to be paid over $150,000 a year.
right?
Okay, if not, we're doing something wrong. All right, and now, David, what was the second part of that, or what was the other part?
And
And
Oh,
in a policy making position for the business. Now,
and
I
that's where I think it fails. That's why I think associates
yes,
are exempt, because
see if I can.
even if they're W-2 or 1099, that might there. But I think if they're not making policy now, there may be some associates that are not owners that are making policy, that are leading, that have a management role. Those will be considered executives. But if you're just a, like your associate is no different than a hygienist in that respect. They're just a producer. So
so let's debate this, Alex.
yep.
Would I'm specifically thinking about a practice right now? 3 locations, four doctors,
Hmm.
one owner, one owner. But we have leadership meetings. We have leadership meetings where we bring these doctors in and they play a role in how we lead these teams in all 3 of those locations, but they're not owners. They all make more than 151,000. What do we need to put in place to get them to an executive leadership role where they have a policy making position? What title do we need to give them?
They need titles. They need titles. They need to be part of their job description that it says that you have an executive role, senior executive role that you're or that we can interpret from it, right, David, that there are functions because if you just have a leadership meeting and everybody's there and the hygienist and the team, like how that won't fly. And remember, this is all
No.
going to get down to if it's litigated, instead of to be there. And it's also look, it's substance over form. This is law school, right, David? Is you can write whatever you want, but if a lawyer says that you form isn't what you're actually, substance, you're not actually doing that, but you call it that, they'll throw it out. So they better really have a policy making experience. Like you at All Star Drive, All Star. I was just commenting how proud I'm like everybody thinks Eric's a CEO, which is the whole point. Our company, we have senior executives that lead. That's different. But if you can't put that on them, so they better really be.
Yeah.
Don't mess around. Judges hate that. If you're just kind of
Yeah.
like,
So so you need to talk to somebody making that legit a lawyer in your area, but it sounds like they need to be able to sign an NDA to be in that
yes,
role.
any
Okay.
contractor, those things, and then
Okay.
we'll
And
spend.
well, you both brought up an important point. I'm sorry to interrupt you, Alex. I
Sure.
think he just brought up an important point because you said sign one. Uh, this the opinion goes on to discuss and this is, I don't want to get too legalese, but the SEC, the Securities Exchange Commission, has discussed executive officers as part of its like reporting duties, and it's putting um, this group of folks under that heading, and it's what the court is going to use as any analysis for whether folks fall under that. And part of that is doing a jobs duty test. So the FTC really spent 500 pages trying to give courts a blueprint for what analysis to undertake for all this.
Wow.
And one of the things they did in whether this person has policy making authority is also is whether they have policy making authority, not even just like input, whether they have
Oh.
authority for the
Mm,
entire organization and would closely
wow.
align to the SEC's definition of executive
So,
officer.
for example,
So
if they're leading team meetings, if they're implementing the All Star Dental Academy training system, if they're helping with hiring, if they're doing things like that that lead the company, if
yeah,
they're,
yeah, and
Firing
sure,
but
if
or
they have the
changing insurance
authority,
you know
if
what,
they have the authority to
you
participation.
know,
fire, right,
and this
David?
is, but you know what, now I'm just saying this, and this is only for those are also not going to be enforced. So this is only until this goes into effect. This only keeps alive those until September. So this is,
Oh,
yeah. So I just wanted to throw some water on the senior executive
okay.
Uh-huh.
thing. Those are also out the window. So
What do
this
you
is
mean they're out the window?
they want all non competes gone. They
Wait,
want
wait.
So they're
all,
Even if you're a
basically
yeah,
senior
saying there's a
executive,
even
gone.
yeah, yep. This is
so they're only
only
saying, Alex, I
they're gonna
got you,
keep
Alex, I got you.
current. These are
Well,
this
I
is for
got you
new
on the
ones. Okay, hold on.
non solicitation and the
So
IP.
let me
You can't
say
go
this.
anywhere. Go ahead. Yeah, go ahead.
What it's saying is essentially no new ones. So it's going to grandfather those in.
Oh,
So
Oh,
really?
let
That's a
me so hold on,
grandfather
hold
thing.
on. Let
Wow.
me see this real
so
Oh
maybe
my
it's
quick.
back
So
gosh.
to what we
that's
thought.
This is nuts.
it is really a mind-boggling
While
expansion
you're
of
looking at that,
executive
just to be
power
clear,
because
um, just to be clear, you're buying a practice, you're buying a list of,
yeah,
you're buying the practice in either form. You can enforce a non-compete for the most part. That's a business sale, correct? That
existing one,
doesn't fall under this.
right?
Exist.
Ex,
Okay, I'm
ex,
selling the
ex-
business to you. That's different. Where we're getting into trouble, so that's clear. Where we're getting into a problem. So you're saying, and then if you actually have associate dentists that are senior executives, this will be grandfathered in. But anybody new, even if they are a senior
Yeah,
executive, you cannot do
won't work.
non-competes. You may have to go the route, but we were saying you still can go the route as this is my IP. So I don't want to pick on Eric, but if Eric were, I mean, well, I would say so if
I
one
am.
were to, he's a president of coaching, right? So he would go and say, I want to build another coaching company using all the IP. So you can't stop him from coaching. You can't stop him from so you can as a senior executive. Let's say he was a new president of coaching. You cannot uh he cannot start he could start his own coaching firm, he can do things, but he cannot take the IP of All Star or the clients of All Star. That can be enforced. Now, how do you enforce it if they come around? Is that what you're saying? Or with the dentist, same thing. I don't pick on Eric. This is for the entrepreneurs that are listening. If you're a
sure.
dentist and
What
the
I'm
associate leaves, okay, this is the important thing. The associate leaves, then you can stop them with the other provisions by using your IP. So if they are senior executives, they're using your IP to train people to run things. So this could be, again, we're picking on dentists, but what if you have leadership, um, real leadership dentists that leave? They can't take your IP and use your systems. Because let's say Eric, give me an example. Eric coached, we coach leadership training. This is very important. We do leadership training, high level training for offices, not just phone and scheduling. Now we are giving all star systems that become the systems of the office. Now, this senior executive dentist says, I want to leave and I'm going to start my own dental business using all the systems that I've used, and then reaching out to those patients that we can get them on. You're taking our IP and our IP also are our patients. So you can't use our IP, stop that, do your own IP, and you can't use our IP, which are our patients. You can't solicit them. Those would be enforceable,
yes.
likely.
It, this is designed specifically for worker movement, and intellectual property and trade secrets are still under the auspices of um, s- safe and secure as far as the FTC is their modus operandi goes. Now, will creative plaintiffs, attorneys attempt to try to muddy those waters? That's the thing that I'm curious about. We touched on that before. That I'm curious about how the interplay of all that is going to go,
And
and
let me
whether
just say
there's
that,
overlaps of those provisions.
and
How
let me
how do
just
some of those survive without the others? But
no, no,
yeah, go
sorry.
ahead.
Literally one more. I'll give you the last word. Then I want to wrap it up.
I want
Okay.
second to last
So
word.
Eric's gonna ask a question. David, well, you answer what you're gonna say. David's gonna ask a
Yeah.
question. We're gonna wrap it up. We're also gonna define Leviathan before the end of the meeting, and then
Sure.
remember, David is a good friend of mine, and great political mind, legal mind. I'll make sure to get him back here as this progresses or new legal things come in play. Because when Eric sent me this email, I said, dude, this is a David question. We got to get him on a call. We have no right discussing this without a seasoned attorney. Um, David, what are you going to say? And then go to Eric.
Just a couple things. You asked a bigger important question, and then I led you down a different path. So I just wanted to say, the bigger question is, what do we do now? How is this going forward? The big thing is, as of right now, uh, for your existing senior executives, existing non-competes, existing that already inked to paper are okay and they're
Okay.
enforceable. Okay, starting September 4th, um there it precludes, it bars employers from entering into or attempting to enter into a non-compete
Ooh,
clause from a senior executive. That was the one thing I wanted to
got it.
clarify.
That
Okay,
helps. Okay.
okay, because
Translate that, Alex.
we
Translate
So
it.
started
what
to
he's
talk.
saying
Yeah,
is your agreements are fine the way they are now, assuming that your associates are senior executives, because it's grandfathered in. going forward, you cannot enter into non-competes with any employee or contractor. Can't
Okay.
do it. It's not going to be enforced,
So,
assuming
Right.
this law is upheld.
but let's say I have an associate who has a non-compete, but I haven't made them a senior executive. They don't have any decision-making ability. I should do that now before September 4th.
But again, it's assuming that this is upheld. I actually would probably I would have an attorney ready to go. But if the FC keep your eye on it, if the FTC upholds it, or there's no, or it's being upheld by the courts, we have to follow it. So I would assume, David, we want to wait and see. Watch that date, and within a few weeks, if nothing happens, or so what happened? Let me ask you this, David. If nothing, something will happen before that date. There will be a court. There are already lawsuits, so something has to happen. Now, could it also be deferred, where no decision, meaning because they haven't, or there will be a ruling by that date, whether it's upheld or not?
I
Correct.
I think so, because to me it's a pretty clear question of law of three things. There's kind of and this is, I want to help dentists run their practice, but I could talk about this for 3.5 hours about the legal issues going on with this situation. Uh, but does the FTC have this ability? Because this is something that is uniformly a state issue. Contract law is a state thing. When I sue you for breach of contract, I sue you under state common law, period. Right? States have there's state statutes on non-competes. The United States Congress has never passed a non-compete statute. Florida and California and Minnesota and Indiana have
So
non-compete
let me
statutes.
ask you this,
So
David,
why
because
did FTC
you're
just
a
step
political
in here?
mind.
Right.
Being that we have two sides of government, right?
Yeah.
Two parties. Do you think What's your prediction? Do you think this will be upheld, or do you think this will be challenged and lawsuits and all that? Because
I
states
don't.
and are you don't think it's gonna be upheld?
If you want my
Yeah,
honest opinion,
I
I
want
don't
your
I don't
opinion.
see.
Yeah.
My opinion is that this is not enforceable. Ultimately, this is a uh, ultimately, I think three things. One,
Yeah, then why don't we have this whole discussion? That's
well,
good.
We should have led with
well,
that.
because no, in all fairness, because these are business owners that want to do something.
Yeah,
The United
yeah.
States government just said, "Don't do something. We're not going to enforce your contracts that you just paid a lawyer to prep for you.
And
Five, 10 years
I'm
ago,
not
are not
saying
enforceable."
whether, and we're not
Yeah,
taking a political stance. We don't at All Star. We
sure,
try to keep very, but I'm
sure, of
just saying
course,
from what we see, the other side, because we have one administration that oversees the FTC, the other side is not going to like this for a variety of fronts. Just the fact that they're doing something, and
yeah,
then the states aren't going to like it, and all the representatives. So it's going to be a big hoopla that's going on. Then you have the Supreme Court. Got a lot of things that are happening, so we have to be mindful of it. It's great that it's very scary because when Eric said it, like, oh my goodness, but let's hold on because there's
yeah.
going to be a lot. There's merit to all this, but this is going to be litigated and so on. So we have to keep in mindful. This was a great primer. By the way, for those listening, I know David has got to the point. He doesn't think it's going to be enforceable, but still, this is really, I know Eric's like, whoa, but for some of our dedicated podcast listeners and YouTube subscribers and so on, they like to hear the details. I know some of our dentists, they like to hear all this stuff. It's very interesting. I mean, David's so talented. He could have his own political show. I mean, on policy and stuff. It's brilliant.
I
So this
would
is the way
in
he does
another
it.
life. This was that
Another
was my
life,
that
but
was my dream. I went to law school to do that, and then
and be a history
I
professor
started.
too is one of your
That's
goals
right.
too.
That's right. But
So, anyways, we'll keep you posted on it. Thank you everybody for being on the show. David, define Leviathan.
sure. So it comes from apparently an ancient Hebrew myth that
Yeah, I
comes
saw
from
that.
the
Yeah,
root that means to twist and turn and wind and coil. It's a sea serpent. Apparently, I had no idea that.
it's a
I always,
very well. There's a few definitions.
yeah,
There's a large aquatic creature, or
right,
a thing that is very large or powerful, or a ship.
right.
It's a leviathan. So there's a. It's a what a this guy, man. Great words. Thank you for the word of the day.
I was just thought it
That will
meant
be your
something big.
wordle tomorrow. So,
Right, there you go.
all right,
All right.
David Ehrlich, the managing partner of Ehrlich Law LLC. Eric Vickery, president of coaching of All Star Dental Academy. Thank you for joining us. Remember to follow us on Apple Podcasts, Spotify, YouTube. Get the episodes as they are released, and also Instagram, Facebook. We're everywhere. Share with your friends. And until next time, go out there and be an all star.